Good day, Stryker.
Good day, Professor McGee.
What are you reading about?
Plessy versus Ferguson.
Oh, I see.
I find it a little confusing.
Why is that?
Well, this Plessy guy got arrested, right?
Uh-huh.
For breaking the law.
Right.
Yet, he seems like kind of a hero.
Well, he was.
But he broke the law.
Yes.
I don't understand.
Oh, you will. Let's talk about it.
I thought criminals were the bad guys.
Usually.
But not always?
Well, let's just say this incident was no accident, if you know what I mean.
I don't know what you mean. Can you explain more?
Plessy's act of civil disobedience was a test case organized by the Citizens Committee.
Who was that?
The Citizens Committee was a civil rights group who vigorously opposed the Separate Car Act passed by the Louisiana State Legislature in 1890. The law required separate train car accommodations for black and white passengers. The East Louisiana Railroad didn't like the law either because it was expensive to have both white and colored cars on every train.
So they organized the protest by Plessy?
Exactly.
Well, that makes more sense.
They chose Plessy because one of his 8 great-grandparents was black. Even though the other 7 were white and Plessy looked white, the state of Louisiana classified him as a black man.
I see. Why was that so important?
Well, his fair skin enabled him to buy a first-class ticket for the white car.
I'm starting to get the feeling that this is about something bigger than just a guy on a train.
Yes, definitely. Tell me what you've heard so far.
Just the facts, ma'am.
Yeah, just the facts.
The year is 1892. The date, June 7th. A East Louisiana Railroad Company train is getting ready to depart New Orleans for Covington, Louisiana. 30-year-old Homer Plessy, a mixed-race man with fair skin, buys a first-class ticket and takes a seat in the white car. Then, as the train starts to move, conductor J.J. Dowling approaches Plessy.
Say, are you a colored man?
Yes, I am. 1/8 of colored descent.
Oh, well, then you'll have to retire to the colored car.
But I've paid for my ticket and intend to ride to Covington.
But it's illegal for you to sit here in this all-white car.
I'm sorry to hear that. With all due respect, that law isn't fair. I'm staying here. Arrest me.
Private Detective Captain Chris Kane, hired by the Citizens Committee, then comes aboard to arrest Plessy. He is thrown into jail, but released the next day on a $500 bond. Case closed, correct?
Nope. To the contrary, the case was just beginning. 1 month later, Plessy's case was heard before Judge John Howard Ferguson. Lawyers from the Citizens Committee, led by Albion Tourché, defended Plessy. Tourché argued that Plessy's civil rights under the 13th and 14th Amendments had been violated. However, Judge Ferguson ruled that
Louisiana, under state law, has the power to set rules regulating railroad business within the state.
The Louisiana State Supreme Court affirmed Ferguson's ruling and refused to grant a rehearing.
So, what did Homer Plessy and his lawyers do?
Well, what do you think?
They appealed the case to the Supreme Court?
Yes, indeed.
And how'd that go?
Well, not so well. First of all, it took them 4 years before the court heard the case.
Whew, that's a long time.
Tourché again argued that the state of Louisiana had violated the 13th Amendment, which abolished slavery.
How did requiring Plessy to ride in the colored car make him a slave?
Tourché's point was that separate cars implied that blacks were inferior to whites, a belief that was central to the institution of slavery.
That seems like a bit of a stretch to me.
The court agreed with you, saying that distinguishing between citizens based on their color didn't destroy their legal equality or reestablish a state of involuntary servitude.
Did Plessy have any other arguments?
Well, his attorney also argued that the state of Louisiana had violated the 14th Amendment.
Why? Remind me what that amendment is about.
The 14th Amendment says that No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law.
Wow, that's a mouthful. What's the point?
The point for Plessy was that Louisiana was treating him differently from its white citizens, so he wasn't receiving equal protection under the law.
And what did the Supreme Court say about all of that?
The court stated that the 14th Amendment ensured absolute equality under the law, not social equality. Separate facilities did not stamp blacks with a badge of inferiority according to the court.
So they established the doctrine of separate but equal, which sanctioned segregation, as long as the separate facilities were equal.
Justice John Harlan, the lone dissenter, predicted the terrible consequences of this decision.
The arbitrary separation of citizens on the basis of race is a badge of servitude wholly inconsistent with the civil freedom and the equality before the law established by the Constitution. State enactments regulating the enjoyment of civil rights upon the basis of race can have no other result than to render permanent peace impossible and to keep alive a conflict of races, the continuance of which must do harm to all concerned.
And that is exactly what happened. Segregation became law. Jim Crow laws, which were a system of laws designed to discriminate against people of color, spread like wildfire across the landscape of America, state by state. The separate but equal doctrine rapidly extended into many areas of public life, including public schools, restaurants, and restrooms.
But the problem was the facilities for blacks were almost always inferior to those designated for whites, right?
Right, but it wasn't until 1954, in the equally important case of Brown versus Board of Education of Topeka, Kansas, that the doctrine of separate but equal would be overturned.
Finally! That took a long time.
Too long.
It's unbelievable to me how easily we can look back now, see the results, and say, what were they thinking?
Hindsight is 20/20, isn't it? That's why I love history. We can learn from others' mistakes, so we hopefully don't make them again in the future.
Well said, Professor. What does hindsight is 20/20 mean?
It refers to how clear the correct decision can seem when looking backwards in time.
Kinda like Monday morning quarterbacking.
Exactly. It's much easier to decide what the correct play should have been after you've seen the results of the game.
You know, I played a little quarterback in gavel school.
You did?
Yes, I remember it like it was yesterday. We're playing the Whigs, and it was 4th and long. I dropped back to pass, and I got blindsided.
Oh, funny little gavel. So, what case would you like to learn about next?